I call Eugenie Sage.
E te manga o te whare tana koe, ngā mihi nui kia koutou. I'm very pleased to take a call on the Building Earthquake-Prone Buildings Amendment Bill for the Green Party, and I'd certainly like to acknowledge the 185 individuals who died nearly 5 years ago today. I think we were certainly very conscious of them in all of the work that we have done on this bill. It's certainly a bill, as Todd Muller said, that is a good bill. It improves the system for managing earthquake-prone buildings, it defines them, and it establishes national timeframes and procedures for strengthening them. We in the Green Party originally opposed the bill as introduced, and that was primarily because of the provisions in it around unreinforced masonry buildings and the exemptions in relation to access provisions for people with a disability when building owners were strengthening their buildings. And there have been some quite major changes in both those areas, so we are very pleased now to be able to support the bill. And as an MP, I'm certainly very grateful to the members of the Royal Commission on the Canterbury Earthquakes. The Commission did a very in-depth review and a very substantive report which provided the basis for this legislation, and particularly acknowledge everybody who appeared before the Commission, particularly the families and friends and workmates of people who died or who were injured in the quakes. And the Commission, in its report, identified some quite significant problems in the Building Act, both in the way it was drafted and the way it was being implemented. It highlighted that there were some gaps in information and quite big inconsistencies and variability in local practice with the way the Act was applied, and a very poor understanding across the country of risk. So it was the Commission that provided options for reform and some quite detailed recommendations for change. Mr Speaker, this bill was introduced to the Parliament in December 2013, and it's been before the Parliament for over 2 years. But that has enabled a very thorough and comprehensive and consultative process by a select committee. And I think it's a process because it enabled 2 opportunities for public submissions, both on the bill as introduced and then on the interim report of the Select Committee and the recommendations which officials were bringing back to change the bill, that has resulted in these significant changes. And I think it's a process with these 2 opportunities for submission and the consultative approach that the ministers took, both Maurice Williamson and the Honourable Nick Smith, that other legislation in this Parliament would benefit from. Because the committee heard some 121 submissions, we were able to hold hearings in Auckland, Wellington, Christchurch and Dunedin, and then issue that interim report. And I particularly acknowledge the number of submitters who put in a huge amount of work into very detailed, constructive and informed submissions. They had a major impact in changing this bill. They were from earthquake survivors, local authorities, property owners, engineers, scientists and GNS. And would particularly like to acknowledge the role of the science community and earthquake engineers. And I think it would benefit legislation if we heard more from CRIs like GNS when we were developing legislation. In the Green Party, we were very pleased that the government rejected the approach which the employers and manufacturers and the Wellington Employers Chambers of Commerce were recommending. And they were saying that the market was already pricing the risk posed by earthquakes, so there wasn't any need to regulate. We certainly believe there is a need to regulate. And would also like to acknowledge, as others have done, Dr. Anne Brower, because it was her advocacy on unreinforced masonry buildings, and in particular parapets, facades, verandas and the like, that was quite compelling in influencing the Select Committee at that interim report stage to then go on and change the provisions in the original bill. Because in their bill as introduced, there was a failure to give sufficient priority to reducing the risk of loss of life and of serious injury from these features of unreinforced masonry buildings like parapets and verandas. And that was really disappointing to the Green Party, and we had to work quite hard with others in the Select Committee to get that changed. because the Royal Commission had already noted in its report, and I quote, "The majority of deaths due to the collapse of unreinforced masonry buildings in the February earthquake occurred in public places outside the buildings that failed due to the out-of-plane collapse of facades, gable ends and parapets." So it was disappointing that officials didn't recognise that in the bill as introduced. And it was Dr Brower and others, such as GNS, who argued, of course, that it was much cheaper and more cost-effective if building owners focused on repairing these features like verandas and parapets as a priority, given that that would be cheaper than repairing and strengthening the building as a whole. So we're very pleased that that has been changed, but there's still a shortfall here. It is that the provisions in 133AC of the bill and 133AD require councils to use the special consultative procedures of the Local Government Act to consult their communities on which thoroughfares, whether they be roads or footpaths, and which unreinforced masonry buildings should be priority buildings for the purposes of having the faster time frame for strengthening them. And in our view, and also in the view of the Royal Commission, it was an engineering and a technical exercise as to whether unreinforced masonry features should be strengthened. It shouldn't require councils to consult with their communities using those quite detailed procedures under the Local Government Act. So it should be an engineering and a structural assessment rather than a consultative process. And it's interesting that these unreinforced masonry buildings are a special category of priority buildings, because for the rest of the priority buildings, the councils just get on and do this assessment. They don't require consultation, and we think the unreinforced masonry buildings and their features should be in that same category. And I guess one of the other issues in terms of the consultative requirements is that that imposes more cost on councils, and that is ironic given that the minister that's in charge of this bill has also been very critical of councils for their cost regimes. So we think that these unreinforced masonry buildings and their features should be on a similar status to the other priority buildings which the bill sets out. The other issue that we are very pleased has been amended is in relation to the provisions requiring the provision of facilities for people with a disability when buildings are strengthened. But my colleague Mojo Mathers will discuss that issue in more detail. The only other remaining issue that we have some concern around is the methodology that's going to be used to identify earthquake-prone buildings and how this has been left to subsequent regulations. Now, that methodology, I think, is of interest to councils around the country. There's been quite a lot of discussion about it. Councils such as Hamilton have already done quite a lot of work and developed a methodology to identify these buildings, and it would be good if officials were able to have progressed the regulations before the actual bill was passed. But, Mr Speaker, I think in conclusion, the way the Select Committee dealt with the bill, and I congratulate the Chair, Scott Simpson, for his chairing, in a consultative, cross-party way, did significantly improve the legislation, and we are very pleased to be part of a Parliament which has worked hard to significantly change, improve the bill, and I hope to provide a policy basis for work to strengthen buildings so that we're not in the position that people were in Christchurch again. Thank you.